Now, this is what the conference has been building to. We've got the elders of our community that have had the vision that we've been talking about during this conference from the very beginning, before it was popular and before the actual adoption of all the laws and the standards and the seals and the certification processes. The people behind what we're experiencing today are here with us, or at least two of the leaders, or three of the leaders. And we're going to start tonight with Jim Gerritsen. Jim has been extremely active as an organic farmer in the state of Maine and with MAVCA in the early years especially. He's been his farm, Wood Prairie Family Farm, has been certified by MAVCA since 1982. And the Gerritsens are focused on the production of organic, early generation Maine certified seed potatoes. They said it couldn't be done. Seed crops, vegetables, and grain. But beyond that, Jim is an activist farmer. And this is where we intersect at a national level. He has been active in the organic community with NGOs for 4 decades. And he is president and founder of the Organic Seed Growers and Trade Association, OSCATA, which acted as the lead plaintiff in the landmark organic community federal lawsuit, OSCATA versus Monsanto. And Jim will probably talk about that a little bit under the sort of banner of corporate and government accountability. Jim, fill us in on more of the details and background, but I think I won't take any more of your time, so why don't you join us up here? Thank you.
Okay. That's our farm. I drove down yesterday. It takes about 5 hours to drive down. It's about 300 miles north of here. What you see there, we call it Bridgewater, Maine, because that's where the nearest post office is. In fact, right there is our buildings, and this is called Kinney Road, and that's a town line road. On this side of Kinney Road is the township of Bridgewater, population 612. On the far side of that is part of the unorganized territory in the state of Maine, which is about half of the land area in Maine. And it's a very sparsely populated half of Maine. In all of the UT, there's about 7,000 residents. The way things are set up in Maine, everything's set up town government 6 by 6 miles. So in our township, TDR2, Township D, Range 2, and administrative title, we've never had enough people to give it a name. There are 23,000 acres and 6 by 6 miles, and there are 8 residents in our town, and there are 6 of them right there. So I wanted to bring this into view because I think geography often, determines important considerations. So the picture you see there, that kind of isolation is perfect for raising seed. Problems come from neighbors. If you don't have neighbors, you don't tend to get problems. So in terms of raising organic seed, cross-pollination, transgenic or genetically engineered contamination, those are all minimized dramatically by being isolated. So we were kind of led to getting into seed, and we've been doing seed now for organic seed for 30 years. So our main crop, as Jay said, is growing organic seed potatoes. And up northern Maine, 60 years ago through the early 1950s, northern Maine, specifically Aroostook County, was the leading potato producing region in North America. We were ahead of Idaho, Colorado, Washington, the states that have in recent decades taken over. And to this day, even though our production has gone down as production has shifted to the west, there are still more potatoes grown in Aroostook County, Maine than any county in the United States. We're one of the last areas in the United States where they still close the schools down in the fall, every fall, so that the kids can work harvest. So those kids that you saw in our family, they have never missed a potato harvest. The oldest girl, Sarah, she was born at the end of October, so she was about 11 months old for her first harvest, but Caleb, the boy on the right there, he was 3 months old with his first harvest, and we had a photographer from the National Geographic out that fall completing a one-year-long project on sustainable ag, and my wife and Caleb was in a little baby pack and looking right at the camera, and it was a 2-page spread in this article, so we're transitioning the farm over, and Caleb is the primary now, and we're working for him, but he's never missed a potato harvest in his life. So what I want to talk about tonight is, why some of us have so much commitment to organic. And I think this encapsulates this. This is a relatively recent study that was out this winter from Washington State University. They looked at 12 different metrics, and as you can see, with organic on the right, conventional as compared on the right, looking at different metrics such as soil quality, energy use, biodiversity, ecosystem services, employment of workers, minimize pesticide residues. You can see how superior and how advantaged organic is over what has become the dominant conventional agriculture, which is really skewed, and there are some serious problems. So I think that's a nice graphic in that it shows the balance and benefit of the organic system as the superior production system, and some of the approaching catastrophes that we have within conventional agriculture today. So I want to take a little time telling you a story that impacted me, and it impacted the state of Maine, and it continues to impact the state of Maine. This is a little caterpillar, and if you look close, those are needles on a fir tree, so that's magnified. That caterpillar, called a spruce budworm, is probably about a ½ inch long. And for such a little fella, he's caused a whole lot of contention here in the state of Maine. And here's the problem. The spruce budworm, despite its name, it prefers fir trees. In a given situation, it will defoliate 70% of fir, typically over mature fir, and 30% of spruce, and it can become a significant economic problem. And this is something I think important to understand. For eons, the spruce budworm has been part of the spruce fir boreal forest in northern Maine and into Quebec and New Brunswick and beyond. But it's been doing fine. Its normal cycle is a 40-year cycle. For 35 of those 40 years, you can't even find a spruce budworm. They're just not to be seen. But then at the beginning of that 36th year, you start to see the population increase as a J-curve pattern. And by the 5th year of that increase, they have become so concentrated that invariably a disease will pass through, and because of their great concentration, their population plummets. So this has been going on for thousands and thousands of years. But when humans come, when white European settlers come and they see all these trees in Maine and they build pulp mills to turn wood pulp into paper, this becomes not an ecological problem, but it becomes an economic problem. So this is a map of almost half of the state of Maine. It's the northern part of Maine, surrounded on 3 sides by Canada. It's 10 million acres. And the key on that indicates that that 10 million acres is all prime habitat for the spruce budworm. Again, spruce and firs being the dominant species. And because of the desire of leaders in the state of Maine to keep the wood alive and growing so that they could keep the mills fed, to keep the jobs going. Beginning in the 1950s, there was a massive project called the Spruce Budworm Suppression Project. And in its heyday, which continued until the 1970s, it was the largest spray program in the United States. Annually, about 4 million acres were being sprayed. Bigger spray program than grasshopper control in the plain states. So here's a graph which indicates the population buildup. What I think is significant is that back in the 50s, they began spraying DDT at that time to try to kill the budworm. For 25 individual years, they renewed this as an emergency spray program. And as we heard earlier today, that one of the benefits, the follow-throughs from Rachel Carson, was the establishment of the Environmental Protection Act, which required the filing of environmental impact statements for projects like this. But because they were termed emergency projects, renewed 25 individual times, they were exempt from that. So I guess part of what I want to say is we see today in government, within the economy, we have collusion between the corporations and the government. We're feeling it in the organic industry, but I want to point out that this is not a new invention. We're talking back 60 years or better. The same kind of collusion has been going on, and I do call it collusion. In fact, this 4 million acre spray program was so big. I mean, that's one of the converted bombers that were used. That was owned by Globe Air out of Tucson, Arizona, and they had 60 fixed wing aircraft, not all as big as that, but 60 aircraft that were spraying this land. The spray program was so big, there were only 2 companies in the United States big enough to handle the spray program, and Globe Air was one. The cost of this program was so great that the state of Maine really didn't have the cash flow for it. So this was all done for the benefit of the paper companies, which, for most of Maine's history has controlled Maine politically. They would loan Maine the money to conduct the spray program, and you might ask, well, why didn't they just pay for it themselves? In Maine's state constitution, there is a limit of liability for the state, in that if you're going to sue the state, you can only sue them up to a certain level. The paper companies didn't want to take responsibility for this because, what if some of the, DDT or carbaryl or some of the chemicals they use, what if it turned out that this was a really terrible chemical and there were birth defects or what have you? They didn't want that liability. So in a very unassuming manner, beginning back in the 50s, the state of Maine said, we'll do it, knowing that there would be that limitation of liability. And that really denies citizens their right to seek redress when there's a problem. So Maine, as you may or may not know, Maine is the most forested state in the nation. 90% of Maine is forested. So, now that electronics has gotten big and the demand for paper has gone down and world competition, the Maine paper mills and the jobs that they provide are a fraction of what they used to be 30, 50, 60 years ago. But it's still a major impact on the economy. So, year 1979, I'd been farming. I was 24 years old. I'd been farming for 3 or 4 years by that time. And early in the spring, I sent my application into MOFGA to become certified organic for the first time. 1 month later, they started to do the spray project in my area, and I had already filed with the state telling them that I didn't want to be sprayed. And in fact, they placed a buffer around plots like ours, so it was an 80-acre farm, and we had a 300-acre out area that they weren't supposed to spray. The planes went by, and they sprayed us with 7. Carbaryl is the fancy name, but 7 is the product name, and that's a prohibited material under organic standards. So I had optimism of getting certified for a month, and then once we were sprayed, that prevented us from getting certified until, as Jay said, until 1982. Later on, I found out that a friend of mine in town who had a portable sawmill was sawing right next to a big white farmhouse about 3 miles directly south of us, and he was directly sprayed by the same planes. And in that, the protocols were that houses were to be have a buffer of 300 feet, and he was right next to it. He got sprayed directly as well. This was basically a spray program out of control. The following winter, I don't remember which agency it was in Augusta. It was probably the Board of Pesticide Control. But they held a hearing on Globe Air as to whether they should renew their spray license. And a lot of us were angry. And to give you an idea of how tense this was in Maine, that preceding summer when these spray incidents were going on, farmers were very unhappy. And they were saying, in some cases, that they would shoot down any plane that flew over their land. This is the sovereign movement that is strong in Maine, and many of us feel that we have a right to farm the way that we want, and no one has a right to contaminate us. So the governor at that time famously came out and with great emotion said that anyone shooting down a plane that resulted in a death would be charged with first-degree murder. That's how tense this was. So we were only too happy to go down to this hearing in Augusta the following spring. The hearing began at 1 in the afternoon, and I testified at about midnight. Our side had a lawyer from Portland. He had a three-piece, what I remember is he had a three-piece suit on and LL Bean boots. The president of Globe Air, who was the project manager for this, he was kind of on the witness stand, and our lawyer was, kind of cross-examining him. What was fantastic and got an audible gasp from the audience is that our lawyer got the president of Globe Air to admit that he had never read the label on the barrels of chemicals that they were spraying. So the basic requirement that every farmer abiding by FIFRA, the Federal Insecticide Rodenticide Act, it requires you to be in compliance and you have to be in compliance by reading the label, then you have to follow it. So when the president of the largest spray company in the country admits under oath that he had never even read the directions, that's not being a very good project manager. So our lawyer immediately moved that Globe Air be disqualified for spraying the next year because clearly they had violated the law and were not qualified. Well, it was a kangaroo court, and the officials that were in charge backpedaled and say, well, we can't be too hasty here. And in fact, they were given the right to spray again the next year. And I came away from that, as an unhappy citizen. Here, we'd gone to the government, we'd explained this is not right, and here you're not even upholding the law. So that was 37 years ago. The interesting thing now is, it was 30 years later, spruce budworm is starting to increase its populations again. They're finding numbers. I read an article in Quebec, and there's, we're now going to see how much has Maine matured in its thought. I will say this, in the recent years prior to the collapse, you can see the collapse about 1986 or so, they had switched to BT, Bacillus thuringiensis. So they got away, DDT stopped wording, they switched to carbaryl, and then they did switch to BT. So they went in a better direction, but I think it remains to be seen how much they have really learned out of this. And I guess this is something that influenced me, and I've been hypersensitive about this issue of organic farmers having a right to farm and a right to be free from trespass, whether it be chemicals, whether it be genetically engineered contamination. Here's a picture that I think, we've got a problem. It is an economic problem. Maine is a poor state. The paper mills have been, a beacon good paying jobs in rural Maine, which really needs it. But when you're trying to manage 10 million acres by out-of-state multinational paper companies, their way of managing is to come in every 50 or 60 years and clear cut. You know, had this been managed like those of us who have Maine land, we all have woodlots. You know, the land that's too wet to farm is in woods. So we manage that woodlot, and we cut as much fir out as we can to favor the spruce, which we know is going to be beneficial. But we have a diversified woodlot, and that's what you need, whether it's in the woods or whether it's on the farm. You want diversity, and that's the strength. You can't go in and say, well, gee, we've got a mess here and we're going to have to spray for it. You've got to, if you're a sane society, you've got to have a plan, and you've got to manage as the main alternative to using chemicals. And you know, with the diversity that we have, if we did a better job of managing, I think that's how you get away from having to spray chemicals that are harmful. So I'm going to tell you about, or at least just mention two books that I really think everybody should read. This first one is by Dr. Mary Wood, who for many years was at University of Oregon at Eugene, and I believe that now she's up in Idaho. But it's a book, you know, it's kind of a lifetime's work for her, and it's promoting this concept of the public trust doctrine, and I really recommend that everybody get a copy and read it. The primary thesis of the public trust doctrine is that government simply does not have the authority to privatize the commons. And, you know, what are the commons? Well, it's the air that we breathe, you know, the water, the rivers, the sea, and the seashore, and seed. And seed has been, for the 10,000 years that we have been conducting agriculture, seed has been in the public sector. It has been selected and developed by your ancestors and my ancestors. And it's only in the last 125 years that Western seed companies have decided that this is something that they would like to own. And they've made progress in taking that ownership away from the people. Importantly, there were Supreme Court decisions 100 years apart in 1892 and 1983 that referred to this public trust doctrine, and in the early part of the 1800s, it was a significant doctrine within jurisprudence in the United States. So here's a practical application of that. Say a company wants to move into an area, and they say, well, yeah, we're a factory, we're going to pollute the air, but think of all the jobs we're going to bring. Think of all the tax revenues you're going to get. Well, the concept of the public trust doctrine is that the government doesn't have the authority to be able to sell a pollution permit to that factory to come in. The government says, well, gee, if you're going to give us jobs and you're going to give us tax revenues, yeah, go ahead and come in, just don't pollute too much. But what if you're the mother of a child that's got asthma? So, in effect, the government has sold your right to clean air, privatized that, and sold it to the corporation, then giving them the chance to pollute the air. Well, the public trust doctrine, which goes back 2,000 years to Roman times, says that the government does not have the authority to privatize the commons. The commons is owned by all of us. The government cannot take that and sell it to a private concern. They don't have the right to pollute the air because it hurts the people as a whole. It hurts the commons. So, all this stuff is reinforced by the Magna Carta. Now, the Magna Carta was the first signed restriction on the oligarchy in 1215. English common law, which came from the Magna Carta and what our laws came to, were based on this idea that there is a limit to government's power. So that limit is based on the supremacy of the individual or the commons greater than the oligarch. So you have this expression, a man's home is his castle. This concept is that one's home or one's sanctuary can't be violated by government, by corporations, or something coming in. And this is how English common law has gone on, and how agriculture in this country and back in England has worked for hundreds of years. If If I have a herd of cattle and you're my neighbor and you've got a nice clover field, it is not your responsibility to put up a fence to keep my cattle from eating your clover. It's my responsibility as the possessor of the harm to restrain that potential harm that would cause harm to the commons. So for hundreds of years, farmers have gotten along, living and working side by side because of this application of common law, to where whoever possesses the harm, they are restrained in their activity. And that's important. And what's the problem is that has been reversed in the last 30 years in agriculture. So jump forward 700 years, and this is our lawyer, Dan Ravisher, executive director and founder of the Public Patent Foundation in Manhattan. And he became our lawyer in what became a major landmark federal lawsuit that Jay alluded to, called Oscada et al. V. Monsanto. And we filed that 5 years ago at the end of March in federal court in Manhattan. It was a very large plaintiff group. We had 83 plaintiffs, including MOFGA, including Beyond Pesticides, including Center for Food Safety. The 83 plaintiffs in the group were comprised of individual family farmers, independent seed companies, and agricultural organizations, which if you took up all of the members in the plaintiff group, was over 500,000 citizens in both the United States and Canada that were involved. So we had two goals that we were trying to achieve with this lawsuit. Under the Declaratory Judgment Act, a law passed by Congress about 25 years ago, we were challenging the legality and constitutionality of Monsanto's GE seed patents. We had prepared four self-standing legal arguments that we felt would win the day that would prove that the U.S. Patent and Trademark Office had erred in their granting of seed patents to Monsanto. The second goal that we had was under the same Declaratory Judgment Act. We wanted to protect family farmers who were illegally trespassed upon and contaminated by unwanted transgenic content from Monsanto. And because of that contamination, they were subject to litigation for patent infringement by Monsanto. Under U.S. patent law, which I might add has been written by the corporations, it doesn't matter whether you had intention to possess another's patented material or whether you even had knowledge of possession. If you were in possession of another's patented material and have not signed a licensing agreement to hold that possession, you were open to litigation for patent infringement. And Monsanto, as the record shows, is the most aggressive patent bully in the history of the world. So organic farmers were subject to extreme economic duress of having our crops contaminated. Contaminated organic seed has zero value in the marketplace. But to add insult to injury, we were also open to litigation by Monsanto, and Monsanto does like to make examples of others. And we thought this isn't fair. We're not their customers. We don't want their seed. We don't want their technology. We want nothing to do with them, and we don't want to have to defend ourselves in court when they trespass onto our farm. So we want the court to declare ourselves free from any liability in Monsanto's case, should they contaminate us. That was the reason that we went to court. From the outset, Monsanto wanted to keep this from going to trial, as is common legal strategy. They challenged us on standing, saying we don't have a right to sue them. What I believe that they were scared to death of is that through the discovery process, we would get access to their internal files that we felt would probably prove, similarly to the tobacco industry, the smoking gun, that they know internally that these genetically engineered crops are bad news, and we wanted to get our hands on that so that we could prove our case. One of the arguments that we were going to make goes back to 1820 when Supreme Court Justice Story issued a very famous ruling, and he said that if someone were to bring a poison to the patent office and try to gain a patent for it, they would not get a patent because you cannot patent a poison that hurts the people. And this was one of the bases that we were going to fight them on. Well, turns out Monsanto's lawyer was a man named Seth Waxman, who under Bill Clinton, he was Bill Clinton's Solicitor General, the top lawyer in the United States. The district court judge, Naomi Buchwald, was a Clinton appointee, and they were both part of the corporate Democratic establishment on the East Coast. So we don't feel that we got a fair trial by any means, or a fair hearing on the motion to dismiss. And basically, Judge Buchwald, in her ruling granting the motion to dismiss, ridiculed the farmers, saying, you're doing this as a publicity stunt. There's no substantial controversy here. There's no risk to you as farmers. So we immediately appealed to the Federal Court of Appeals, or the Court of Appeals for the Federal Circuit in Washington, D.C. And 1 year later, we had our oral argument there. A few more months after that, and they issued their ruling, which completely repudiated the position of Judge Buchwald. They said these farmers have a valid claim, and that they said in their ruling that contamination is inevitable. Then, that was the good news. The bad news is that they tried to remedy this without allowing us to go to trial to argue our case. So they issued a judicial estoppel, which is an order. And the order, basically, Monsanto had been on the web and even in court had been saying, we're nice guys, we would never sue these farmers. And we know Monsanto well enough that we don't believe anything they have to say. So this judicial estoppel requires Monsanto to make good on this claim that they wouldn't sue us. They identified trace amounts as 1%, and they said that so long as it's inadvertent means of trace amounts, which the court defined as 1%, Monsanto is not able to come after us. And we thought, well, the three appellate justices were trying to help remedy this situation. We thought it would be better if they would send this back to district court where we could argue our case. After all, that is what Americans think that the judicial system is all about. If you're wronged, you get into court, you argue your case, and then on the merits of that case, you see whether you win or lose. Not to be denied justice by being denied standing. The problem is when they gave us that partial protection, that removed the substantial controversy. So that basically then gave Monsanto the victory in terms of winning and standing, because that estoppel took away the substantial controversy. So we won on principle, but we lost on that detail. So we weren't satisfied with this as a safety. What if our contamination level was over 1%? No indication there was any protection for us. There was no clarity. We're seed growers. We grow a crop of seed, we hold back a portion of that seed, and then we sell the rest. There was no clarity that we had a right to sell seed. There was no clarity that we had a right to plant seed, just that we had a right to possess seed so long as it was under 1%. So we appealed to the U.S. Supreme Court, and just for background, the Supreme Court has offered 5,000 to 6,000 cases a year, and they have time to accept 80 to 100 cases. So there's a 99 out of 100% chance that your case is not going to be accepted. And that's in fact what happened to our case. They passed over it. That meant that the ruling of the U.S. Court of Appeals is the ruling which stands and is now functionally the protection that for the first time in U.S. history, family farmers, and not just farmers within our plaintiff group, but any family farmer farming on American soil is granted this protection from Monsanto, that if they, through inadvertent means, are contaminated 1% or less, Monsanto cannot sue them. So it was a partial victory. It wasn't what we wanted, but it was better than when we had gotten in there. And I've talked to several lawyers who were amazed that we were able to make that much progress. Took 3 years and $1 million. The legal fees were waived. It was pro bono work provided to us by the public patent foundation, but it was $1 million worth of legal costs that went into this. So wouldn't it be nice if this judicial system was as functional as how we teach our kids in school and what makes our country different from the other countries? So I'm about done here, but here's my second book. I'm just about done reading this book. It came out a month ago. Colin Woodard is an analyst and an investigative reporter here in the state of Maine. He was born in Maine, and that's why he's here. I've met Colin. He's a brilliant man. His preceding book, the book that preceded this, was American Nations, that some of you may be aware about. And this is the idea that the United States is made up of 11 separate nations that have had varying political alliances over the last 300 years, and that the political lay of the land is Yankeedom and its allies in pitched battle against the Deep South and its allies. And American Character is kind of an update on this and goes into more of the thinking, and it's an extremely valuable book. And if there's any lack of clarity as to the battles that were going on, whether it's in a national presidential campaign, whether it's at the NOSB, the rise of corporate influence in politics, this is the book that you want to read. It's very well written. Colin is a clear mind, and I think this really is a must-read for anybody who is concerned, and I think everybody in this room would benefit from it. So that's it, and